Hello everybody, Andrew Reed here with the NCA Exam Study Guide for Constitutional Law in 2023. Today we're going to be looking at Part 10 of this study guide, which will go over Aboriginal Title, treaty rights, and the duty to consult. Keep in mind that we're just following along with the NCA exam syllabus. I'm just case briefing and examining the notes that they have therein. Okay, let's go ahead and get started with, I believe it's Syllabus Nation versus British Columbia 2014. This is a case on Aboriginal title. A couple big issues here, whether the test for the Aboriginal title required proof of regular and exclusive occupation or evidence of intensive and site-specific occupation, whether the trial judge in this case erred in finding the Aboriginal title established, whether the Crown breached procedural duties to consult and accommodate before issuing logging licenses, and finally, whether the Crown incursions on Aboriginal interest justified under Section 35 of the Constitution Act framework. So whether those incursions were justified. There's a few more issues mentioned here that are worth mentioning. Whether the provincial laws of general applications apply to Aboriginal title land, whether the Forest Act on its face applies to Aboriginal title land, whether application of Forest Act ousted by the operation of the Constitution, and whether the doctrine of interjurisdictional immunity should be applied to lands held under Aboriginal title. Okay, some background here. So for centuries, this First Nation, which was a semi-nomadic grouping of 6 bands sharing common culture and history, have lived in a remote valley bounded by rivers and mountains in central British Columbia. It is one of hundreds of indigenous groups in BC with unresolved land claims. In 1983, BC granted a commercial logging license on land considered to be part of their traditional territory. The band objected, sought a declaration prohibiting commercial logging on the land. Talks with the province reached an impasse, and the original land claim was amended to include a claim for Aboriginal title to the land at issue on behalf of all the First Nation people of that band. The federal and provincial governments opposed the title claim. So the Supreme Court of British Columbia held that occupation was established for the purpose of proving title by showing regular and exclusive use of sites or territory within the claim area, as well as to a small area outside that area. They applied a narrower test based on site-specific occupation, which required proof that the Aboriginal group's ancestors intensively used a definite tract of land with reasonably defined boundaries at the time of European sovereignty. And the British Columbia Court of Appeal held that that claim had not been established. So it goes to the Supreme Court, who said the appeal should be allowed, and the declaration of Aboriginal title over the area requested should be granted. And also, they threw in a declaration that British Columbia breached its duty to consult, which was owed to that nation. Okay. So some rules that are used in this test, and then some tests which are excellent tools for the NCA exams. So Rule 1, the Sparrow Test, of course. Under Section 35, a right will be infringed by legislation if the limitation is unreasonable, imposes undue hardship, or denies the holders of the right their preferred means of exercising the right. Then Rule number 2. Whether the evidence in a particular case supports Aboriginal title is a question of fact for the trial judge from the Marshall case. Rule number 3. Aboriginal title flows from occupation in the sense of regular and exclusive use of the land. To ground Aboriginal title, to make it real, occupation must be sufficient, continuous, where present occupation is relied on, and exclusive. This is from Delgamook, if I'm saying that correctly. This case is often cited. Okay, the analysis. Here, the trial judge was correct in finding that this First Nation had established Aboriginal title to the claim area at issue. The claimant group bears the onus of establishing Aboriginal title. The task is to identify how pre-sovereignty rights and interests can properly find expression in modern common law terms. Aboriginal title flows from occupation in the sense of regular and exclusive use of the land. So to get that title, occupation must be sufficient, continuous, and exclusive. Marshall test. In determining what constitutes sufficient occupation, which it lies at the heart of this particular appeal, one looks to the Aboriginal culture and practices and compares them in a culturally sensitive way with what was required at common law to establish title on the basis of occupation. So occupation is not confined to specific sites of settlement, but extends to tracts of land that were regularly used for hunting, fishing, or otherwise, exploiting resources and over which the group exercised effective control at the time of assertion of European sovereignty. So, in finding that Aboriginal title had been established in this case, the trial judge identified the correct legal test and applied it appropriately to the evidence, according to the Supreme Court. While the population was small, he found evidence that parts of the land to which he found title were regularly used by the nation, which supports the conclusion of sufficient occupation. The geographic proximity between sites, which evidence of the occupation was tendered, and those for which direct evidence of historic occupation existed, all that supported an inference of continuous occupation. From the evidence that prior to the assertion of sovereignty, that nation repelled other people from their land and demanded permission from outsiders who wished to pass over it, he concluded that the nation treated the land as exclusively theirs. So the province's criticisms of the trial judge's findings on the fact in the Court of Appeal case are primarily rooted in the erroneous thesis that only specific, intensively occupied areas can support Aboriginal title. Moreover, it was the trial judge's task to sort out conflicting evidence and make findings of fact. Presence of conflicting evidence does not demonstrate palpable and overriding error. Province did not establish that the conclusions of the trial judge are unsupported by evidence or otherwise in error. Absent this error, the finding should not be disturbed. Okay. The nature of Aboriginal title is that it confers on the group that holds it the exclusive right to decide how the land is used and the right to benefit from those uses, subject to the restriction that the uses must be consistent with the group nature of the interest and the enjoyment of the land by future generations. Prior to establishment of title, the Crown is required to consult in good faith with any Aboriginal groups asserting title to the land about proposed uses of the land, and, if appropriate, accommodate the interest of such claimant groups. The level of consultation and accommodation required varies with the strength of the Aboriginal group's claim to the land and the seriousness of the potentially adverse effect upon the interest claim. So one test which comes from this case, government action is consistent with the fiduciary duty owed by the Crown to the Aboriginal group. So more on that in some of the later cases. So where Aboriginal title has been established, the Crown must not only comply with its procedural duties, but must also justify any incursions on Aboriginal title lands by ensuring that the proposed government action is substantively consistent with the requirements of Section 35 of the Constitution Act. So this requires demonstrating both a compelling and substantial government objective, and that the government action is consistent with the fiduciary duty owed by the Crown to the Aboriginal group. This means the government must act in a way that respects the fact that Aboriginal title is a group interest that inheres in present and future generations, and the duty infuses an obligation of proportionality into the justification process. The incursion must be necessary to achieve the government's goal, rational connection. The government must go no further than what is necessary to achieve it, minimal impairment, and the benefits that may be expected to flow from the goal must not be outweighed by adverse effects on the Aboriginal interest, proportionality of impact. Allegations of infringement or failure to adequately consult can be avoided by obtaining the consent of the interested Aboriginal group. And so this Section 35 framework permits a principled reconciliation of Aboriginal rights with the interest of all Canadians. So the alleged breach in this case arises from the issuance by the province of licenses affecting the land in 1983 and onwards, before title was declared. So the honor of the Crown requires that the province consult this nation on uses of the lands and accommodate their interest. The province did neither, and therefore breached its duty owed to that nation. While unnecessary for the disposition of the appeal, the issue of whether the Forest Act applies to Aboriginal title land is of pressing importance and is addressed. As a starting point, subject to the constitutional constraints of Section 35 and the divisions of powers in the Constitution Act, provincial laws of general application apply to land held under Aboriginal title. As a matter of statutory construction, the Forest Act on its face applied to the land in question at the time the licenses were issued. British Columbia clearly intended and proceeded on the basis that lands under claim remain Crown land for the purposes of the Forest Act, at least until Aboriginal title is recognized. Now that title has been established, however, the timber on it no longer falls within the definition of Crown timber, and the Forest Act no longer applies. It remains open to BC to amend the Act to cover lands over which Aboriginal title has been established, provided it observes constitutional restraints when it does so. A little warning from the court there. So this raises the question of whether provincial forestry legislation that is on its face purports to apply to Aboriginal title lands, like the Forest Act, is thereby ousted by Section 35 framework or by the limits on provincial power under the Constitutional Act. And for this, they pull up the good old Sparrow test. Sparrow test. Under Section 35, a right will be infringed by legislation if the limitation is unreasonable, imposes undue hardship, or denies the holders of that right the preferred means of exercising that right. So general legislation, such as legislation aimed at managing the forest in a way that deals with pests or forest fires, will often just pass this test, no infringement. However, timber licenses on Aboriginal title land is a direct transfer of Aboriginal property rights to a third party and will plainly be a meaningful reduction of the Aboriginal group's ownership right, amounting to an infringement that must be justified in cases where it's done without Aboriginal consent. Finally, for purposes of determining the validity of provincial legislative incursions on lands held under Aboriginal title, the framework under Section 35 displaces the doctrine of interjurisdictional immunity. Interjurisdictional immunity just can't apply here. Aboriginal rights are limit on both federal and provincial jurisdiction. Okay, so provincial regulation of general application, including the Forest Act, will apply to exercises of Aboriginal rights, such as Aboriginal title land, but just subject to the Section 35 infringement and justification framework, i.e. the Sparrow test. The result is a balance that preserves the Aboriginal right where permitting effective regulation of forest in this particular case. But in this case, the province's land use planning and forestry authorizations under the Forest Act were inconsistent. Some notes here. There's a test for Aboriginal title in Delgamuukw, which summarized the content of Aboriginal title by two propositions, one positive and one negative. So positively, Aboriginal title encompasses the right to exclusive use and occupation of the land held pursuant to that title for a variety of purposes, which need not be aspects of those Aboriginal practices, customs, and traditions which are integral to distinctive Aboriginal cultures. But negatively, the protected uses must not be irreconcilable with the nature of the group's attachment to that land. That is, it is a group title, cannot be alienated in a way that deprives future generations of the control and benefit of the land. Okay, the question of sufficient occupation must be approached from both the common law perspective and the Aboriginal perspective. The Aboriginal perspective focuses on laws, practices, customs, and traditions. In considering this perspective for the purpose of Aboriginal title, one must take into account the group's size, manner of life, material resources, technological abilities, and the character of the land's claim. To justify overriding the Aboriginal title holdings group wishes on the basis of broader public good, the government must show that it has discharged its procedural duty to consult and accommodate, and 2, that its actions were backed by a compelling and substantial objective, and 3, that the government action is consistent with the Crown's fiduciary obligation to the group. And this is from the Sparrow as well. The degree of consultation and accommodation required lies on a spectrum, as discussed in HIDA, which is a later case here. In general, the level of consultation and accommodation required is proportionate to the strength of the claim and to the seriousness of the adverse impact the government action would have on the claimed right. So the required level of consultation and accommodation is greatest where the title has been established. And where consultation or accommodation is found to be inadequate, the government decision can be suspended or quashed. A lot more on this to come. Second of three cases in this particular section of the study guide, we have the Marshall case from 1999, which was in reference to treaty rights. So here, the accused, a Micmac Indian, was, wording of the case, was charged with 3 offenses set out in the federal fishery regulations: selling of eels without a license, fishing during the closed season, and he admitted he caught and sold a lot of eels without a license and with a prohibited net within times that he's not supposed to, according to the license. Only issue at trial is whether he possessed a treaty right to catch and sell these fish under the treaties of 1760-61 that exempted him from compliance with the regulations. So during these treaties, the Aboriginal leaders asked for truck houses for the furnishing with necessaries in exchange for their peltry. So some ancient language there. The written document contained the promise by the Micmac not to traffic, barter, or exchange commodities in any manner except with the managers of such truck houses as should be appointed by the Crown. Well, this trade clause is framed in negative terms as a restraint on the ability of the Micmac to trade with non-government individuals. The trial judge found that it reflected a grant to them of the positive right to bring the products of their hunting, fishing, and gathering to a truck house to trade. He also found that when his trade obligation, the system of truck houses and licensed traders and all that fell into disuse, that this right disappeared. And so this accused was convicted on all 3 counts. And the Court of Appeal upheld that conviction. It concluded that the trade clause did not grant them any rights, but represented a mechanism imposed on them to help ensure that the peace was a lasting one by showing the need of the Micmac to trade with the enemy, or trying to make sure that the Micmac didn't trade with the enemies of the British or unscrupulous traders. So the issue here is whether this accused possessed treaty right to catch and sell fish that exempted him from compliance with the regulations. And that's what's before the Supreme Court in this case. So the rule in this case is there is evidence by conduct or otherwise as to how the parties understood the terms of the treaty, then such understanding and practice is of assistance in giving content to the term or terms. This is from Delgamuuk. So an analysis here. The starting point for the analysis of any alleged treaty right must be an examination of the specific words used in any written memorandum of its terms. So in this case, a truck house provision incorporated an alleged right to trade, but also the right to pursue traditional hunting, fishing, and gathering activities in support of that trade. So the document in isolation doesn't support the appellant's arguments and do not extend to open-ended accumulation of wealth for sure, but the rights are treaty rights within the meaning of Section 35 according to the Supreme Court, and are subject to regulations that can be justified under the Badger test, which I pulled from the Badger case, which is any ambiguities or doubtful expressions must be resolved in favor of the Indians. Any limitations on the rights of Indians must be narrowly construed. This is from Badger in 1996. So the trade arrangement must be interpreted in a manner which gives meaning and substance to the promises made by the Crown. So where a right has been granted, there has to be more than just a mere disappearance of the mechanism created to facilitate, like the truck houses is what he's referring to give the conclusion that the right itself is spent or extinguished. So it needs more than that. So in this case, the Supreme Court upheld the appeal and ordered an acquittal for all the charges. The dissent notes here, while construing the language generously, courts cannot alter the terms of the treaty by exceeding what is possible on the language or realistic, also from the Badger case. Okay, so finally, the duty to consult, and this is Haida Nation versus British Columbia in 2004. And the issue in this case, whether the Crown has a duty to consult and accommodate Aboriginal peoples prior to making decisions that might adversely affect their as yet unproven Aboriginal rights and title claims. And they also address whether that duty extends to a third party. So the background. For more than 100 years, the Haida people have claimed titles to all the lands of Haida Gwaii and the waters surrounding it, but that title has not yet been legally recognized. The province of British Columbia issued a tree farm license to a large forestry firm in 1961, permitting it to harvest trees in an area in Haida Gwaii. So the minister replaced it and upgraded and transferred it, and then the Haida people challenged in court these replacements and the transfer, which were made without their consent and over their objections. They asked that the replacements and transfer be set aside. So the original judge dismissed the petition, but found that the government had a moral, not a legal, duty to negotiate. The Court of Appeal reversed that decision, declaring that both the government and the company had a duty to consult and accommodate the Haida people with respect to harvesting timber. So, according to the Supreme Court, where it went next, the Crown's appeal should be dismissed, but the company's appeal can be allowed, so that the government has a duty to consult, the company does not. Okay, so some of the rules here in this case, and there's a lot, this was a well-written judgment in my humble opinion, where the Crown has assumed discretionary control over specific Aboriginal interests, the honor of the Crown gives rise to a fiduciary duty. This is from Wakeham, Indian Band. The court affirmed the duty to consult regarding resources to which Aboriginal peoples make claim, and quoting, so long as every reasonable effort is made to inform and to consult, such efforts would suffice to meet the justification requirement. R versus Nickel. And the content of the duty varied with the circumstances, from a minimum duty to discuss important decisions when the breach is less serious or relatively minor, though the significantly deeper than mere consultation that is required in most cases to the full consent of the Aboriginal nation on very serious issues. So these words apply as much to unresolved claims as to intrusions on settled claims. This is from Delgamook. The duty arises when the Crown has knowledge, real or constructive, of the potential existence of the Aboriginal right or title and contemplates conduct that might adversely affect it. This is from Halfway River First Nation case. There's an obligation to treat Aboriginal peoples fairly and honorably and to protect them from exploitation. Mitchell case. The nature and scope of the duty of consultation will vary with the circumstances. In occasional cases, when the breach is less serious or relatively minor, it will be no more than a duty to discuss important decisions that will be taken with respect to lands held pursuant to Aboriginal title. Of course, even in the rare cases where the minimal acceptable standard is consultation, this consultation must be in good faith and with the intention of substantially addressing the concerns of the Aboriginal peoples whose lands are at issue. In most cases, it will be significantly deeper than mere consultation. Some cases may even require the full consent of an Aboriginal nation, particularly when provinces enact hunting and fishing regulations in relation to Aboriginal lands. Delgamook. Analysis. The Crown, acting honorably, cannot severely run roughshod over Aboriginal interests where claims affecting those interests are being seriously pursued in the process of treaty negotiation and proof. It must respect these potential, yet unproven, interests. The Crown is not rendered impotent here and may continue to manage the resource in question pending the claim's resolution. But, depending on the circumstances discussed more fully below, the honor of the Crown may require it to consult with and reasonably accommodate Aboriginal interest pending resolution of the claim. To unilaterally exploit a claimed resource during the process of proving and resolving the Aboriginal claim to that resource may be to deprive the Aboriginal claimants of some or all of the benefit of the resource, and that is not honorable, according to the Supreme Court judge. To limit reconciliation to the post-proof sphere, as in after it's been proven, risks treating reconciliation as a distinct legalistic goal, devoid of the meaningful content mandated by the solemn commitment made by the Crown in recognizing and affirming Aboriginal rights and title. He references Sparrow here again. When the distant goal of proof is finally reached, the Aboriginal peoples may find their land and resources changed, diminished. This is not reconciliation, nor is it honorable. It will frequently be possible to reach an idea of the asserted rights and of their strength sufficient to trigger an obligation to consult and accommodate, short of final judicial determination or settlement. To facilitate this determination, claimants should outline their claims with clarity, focusing on the scope and nature of the Aboriginal rights they assert and on the alleged infringements. Knowledge of a credible but unproven claim suffices to trigger a duty to consult and accommodate. The content of the duty varies with the circumstances. A dubious claim may attract a mere duty of notice. A stronger claim may attract more stringent duties. The law is capable of differentiating between these tenuous claims. Claims possessing a strong prima facie case, established claims. Parties can assess these matters themselves. If they can't agree, tribunals and courts can assist. Difficulties associated with the absences of proof and definition of claims are addressed by assigning appropriate content to the duty, not by denying the existence of a duty. So this process does not give Aboriginal groups a veto over what can be done with land pending final proof of the claim, says this justice. The Aboriginal consent spoke of in Delegamook is appropriate only in cases of established rights, and then by no means in every case. Rather, what is required is a process of balancing interests, of give and take. A commitment to the process does not require a duty to agree. But it does require good faith efforts to understand each other's concerns and move to address them. Where accommodation is required in making decisions that may adversely affect a yet unproven right and title claim, the Crown must balance these concerns reasonably with the potential impact of the decision on the asserted right of title and then with the other societal interest. In both the courts and the courts below, this court and the courts below, the province points to various measures and policies taken to address these interests. At the court, the province argued the Haida people were consulted with at some point in the past. So these measures and policies did not amount to, in this court's opinion, that and could not substitute for actual consultation with respect to this particular tree farming license and the setting of the license's terms and conditions. And the court says then, it follows therefore that the province failed to meet its duty to engage in something significantly deeper than mere consultation. It failed to engage in any meaningful consultation at all. Strong language from the Supreme Court. A few notes on this. As for Aboriginal claimants, they must not frustrate the Crown's reasonable good faith attempts, nor should they take unreasonable positions to thwart government from making decisions or acting in cases where, despite meaningful consultation, agreement is not reached. And this is from the Halfway River First Nation case. And then from this particular case, a test. Every case must be approached individually. Each must also be approached flexibly, since the level of consultation required may change as the process goes on and new information comes to light. The controlling question in all situations is what is required to maintain the honor of the Crown, to effect reconciliation between the Crown and the Aboriginal peoples with respect to the interest at stake. The Crown may be required to make decisions in the face of disagreement as to the adequacy of its response to Aboriginal concerns, and then balance and compromise will then be necessary. The second issue in here worth mentioning was whether third parties owe a duty to consult and accommodate. The answer was a clear no from this case. The ultimate legal responsibility for consultation and accommodation rests with the Crown, and the honor of the Crown cannot be delegated. The government's authority over natural resources gives it a powerful tool with which to respond to its legal obligations. The fact that third parties are under no duty to consult or accommodate these concerns does not mean that they can never be liable, however. If they act negligently in circumstances where they do owe the Aboriginal people a duty of care, or if they breach contracts with the Aboriginal people or deal with them dishonestly, they may be held legally liable. But third parties cannot be held liable for failing to discharge the Crown's duty to consult and accommodate. So ends part 10 of this NCA exam study guide. Stay tuned for upcoming segments on the Charter of Rights. Best of luck on your NCA exams. Please, if you got value out of this video, smash that like button, comment, subscribe.